The Equal Rights Amendment, the so-called ERA, was first introduced in Congress back in 1923. I know you all know the history of that. It was passed on to the states by Congress in 1972, ironically the year I was born, Mr. Chairman. This has been around a while. But it wasn't ratified by the required 3/4 of the states before its expiration. In 1983, the ERA was reintroduced, as it had to be following its failure to be ratified before the congressionally set deadline, a deadline that was explicitly relied upon by those states. It was the subject of 5 hearings in the House Subcommittee on Civil and Constitutional Rights, including one hearing called by the minority. It was last debated and marked up in the House Judiciary Committee on November 9th, 1983. It's been quite a while. It was later brought up on the House floor under a suspension of the rules in which no amendments are allowed, and in which 20 minutes of debate time each was allocated to proponents and opponents. The ERA subsequently failed to pass the House of Representatives by the required 2/3 vote. Today, this subcommittee holds yet another hearing on the ERA, which, as we will hear, will have to be passed by Congress and the states under the Constitution's supermajority requirements before it becomes a part of the Constitution. It should not become a part of the Constitution, many of us believe, for a number of reasons, including this one. The bipartisan Hyde Amendment prohibits the use of federal funds for abortions except in cases of rape, incest, or when the life of the mother is endangered. The Supreme Court upheld the Hyde Amendment's abortion funding restrictions as constitutional in Harris v. McRae. But the people's right to protect the unborn would be eliminated if the ERA were to pass. Back in the early 1980s, Representative Sensenbrenner requested that Congress's independent research arm, the Congressional Research Service, provide the committee with its own evaluation of the question. As he said at the 1983 markup of the ERA, quote, "The executive summary of the CRS report says that under strict scrutiny, the pregnancy classification in the Hyde Amendment would probably be regarded to be a sex classification under the ERA, meaning that if the ERA were to become part of our law, restrictions on abortion would automatically be struck down." Today, however, with the benefit of even more recent history, we can see that the concerns of Representative Sensenbrenner in 1983 were justified. 5 years later, in 1988, the Colorado Supreme Court held that Colorado's ERA and its state constitution prohibits discrimination on the basis of pregnancy. 10 years later, in 1998, the Supreme Court of New Mexico took the next step and relied on New Mexico's state-level ERA to strike down a state reg that restricted state funding of abortions for Medicaid-eligible women. In New Mexico v. Choose NARAL, New Mexico to Right to Choose, NARAL v. Johnson, the court held as follows, quote, "Neither the Hyde Amendment nor the federal authorities upholding the constitutionality of that amendment bar this court from affording greater protection of the rights of Medicaid-eligible women under our state constitution in this instance. Article 2, Section 18 of the New Mexico Constitution guarantees that equality of rights under law shall not be denied on account of the sex of any person. We construe," the court said, "the intent of this amendment as providing something beyond that already afforded by the general language of the Equal Protection Clause." More recently, NARAL Pro-Choice America, in a March 13, 2019 national alert, admitted their belief that the Equal Rights Amendment would, quote, "reinforce the constitutional right to abortion. It would require judges to strike down anti-abortion laws," unquote. Look, of course, we all believe, I'm the father of 2 daughters, one of them is sitting in the room this morning, that women should be protected from discrimination based solely on their sex. And that is the law today. The Supreme Court has significantly ratcheted up the standard the government must meet in order to discriminate based on sex since the 1980s. For example, in U.S. v. Virginia, the court stated that, quote, "parties who seek to defend gender-based government action must demonstrate an exceedingly persuasive justification for that action." The court also stated, "The burden of justification is demanding and it rests entirely on the state." As Justice Rehnquist noted in his concurrence in that case, the court had in effect made the government's burden much more difficult than it had been previously. Justice Scalia, in his dissent, pointed out that the standard governing review of the government's actions that discriminate based on sex that had previously been in place was, quote, "a standard that lies between the extremes of rational basis review and strict scrutiny." We have denominated this standard intermediate scrutiny, and under it have inquired whether the statutory classification is substantially related to an important governmental objective. Yet in U.S. v. Virginia, Justice Scalia pointed out that the majority in that case had, quote, "executed a de facto abandonment of the intermediate scrutiny that has been our standard for sex-based classifications for decades," unquote. and replaced it with an even higher standard, he said, which is the law today. The majority opinion in U.S. v. Virginia, it should be noted, was written by Justice Ruth Bader Ginsburg. And hello, Justice Ginsburg, if you're watching us. In the 1970s, she was intimately involved in the preparation of a report published by the United States Commission on Civil Rights in 1977 that specifically supported the federal ERA, as you know, along with its ramifications. If it's adopted, it would include the elimination of the terms fraternity and sorority chapters, for example, and the required sex integration of single-sex organizations, among many other things that I think most Americans today would probably object to.